We're here in the state of Ohio versus Rodney Cuthbertson, case number 24-CR-1344. The defendant is present with counsel Jim Matthews. A 2-count indictment was filed in this case on February 7, 2025. Count 1 is having weapons while under disability, a felony of the 3rd degree, in violation of Revised Code 2923.13A2 with the forfeiture specification. And Count 2 is improperly handling firearms in a motor vehicle, a felony of the 4th degree, in violation of Revised Code 2923.16B with the forfeiture specification. The state has offered for the defendant to plead guilty to Count 1 with the forfeiture specification. It is the state's understanding that today the defendant is going to withdraw his previously entered plea of not guilty and plead guilty to Count 1 with the forfeiture specification, and there is no agreement as to sentencing.
Thank you. Mr. Matthews, is that accurate?
Yes, Your Honor.
And Mr. Cuthbertson, were you able to hear what was just said by the prosecutor and your attorney regarding what they believe your plans are here this morning?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previous entered plea of not guilty to Count 1 and plead guilty to that charge, and I'll go over that with you to make sure you understand what that involves.
Yes, sir.
And if you do that, the Count 2 would get dismissed. We would continue sentencing to a future day to get some reports completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they believe is the fair and right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need me to repeat or clarify anything, if you want a moment to talk with your lawyer to ask some questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Well, let's get started then. How old are you, sir?
I didn't hear you.
How old are you, sir?
I'm 59.
59?
Yes, sir.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication?
No, sir.
Now, you should have been served with a copy of this indictment probably sometime middle of February of this year. Do you remember getting it? That's the document that sets forth the charges you're accused of committing.
Yes, sir.
And did you have a chance to look that over at some point?
Yes, sir.
Now, in that indictment in Count 1, which is the charge you're pleading guilty to, what's alleged here and what you'll be admitting to is on or about November 3rd, 2024 in Mentor Lake County, Ohio, that you, not having been relieved from disability in your operation of law or by legal process, that you knowingly acquired, had, carried, or used a firearm or a dangerous ordinance, and that you were under indictment for or previously been convicted of a felony offense of violence, specifically aggravated assault, a felony of the 4th degree in Cuyahoga County Common Pleas Court back on October 31st of 2002, and or domestic violence, a felony of the 4th degree in Cuyahoga County Common Pleas Court back on October 29th of 2010. That conduct constitutes the offense of having weapons while under disability. It's a felony of the 3rd degree. Do you understand what it is you're charged with and pleading guilty to here?
Yes, sir.
Any questions about it?
No, sir.
Now, the charge also carries what we call a forfeiture specification, which alleges that during the commission of the offense, you had in your possession a tan folio, 9mm semi-automatic pistol, along with some ammunition, which were used as instrumentalities. Instrumentalities is some type of property that's used to commit an offense, a criminal offense. The whole point of this is that at the time of sentencing, by pleading guilty to the forfeiture specification, you would forfeit any ownership interest you have in the firearm and the ammunition. You understand that?
Yes, sir.
Any questions about it?
No, sir.
Now, there is a second count of this indictment that's being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about that count for me?
No, sir.
Well, then before I can accept your plea to count 1 that I just reviewed with you, I need to make sure you understand all of the rights you are giving up. And you first will have a right to trial. And the trial could be to me as a judge, or I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, as to each charge, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a jury trial?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and he would have she would have, what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation to prove you guilty. Before you could ever be found guilty, you are presumed innocent of this charge, and the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since this is a criminal case we're dealing with, that burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of those charges, or that charge beyond any reasonable doubt, before you could ever be found guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, the prosecutor here will be bringing witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses have answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions.
Yes,
we call that cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand
Yes,
that?
sir. No.
Further, if there was someone out there that you wanted to have come to court to testify for you and they weren't willing to come in voluntarily, your lawyer could issue what we call a subpoena, which is an order from the court, which would force them or make them come to court and testify for you and answer your lawyer's questions again if they didn't want to come in on their own. Do you understand that?
Yes, sir.
You realize you're giving up that right.
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but most importantly, the prosecutor here, she would not be allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we did go to trial and you were found guilty of this charge, you'd have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all then regarding these rights we've just reviewed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt, so it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to a felony of the third degree. This offense is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, 30. So I'd select one of those numbers if I was going to impose a prison sentence, 9, 12, 18, 24, 30, or 36. Then that'd be the number of months in prison you'd have to serve if the prison term was imposed. You understand that?
Yes, sir.
Excuse me. Now, are you currently on probation or post-release control or supervision of any other courts or agencies?
No, sir.
Do you have any other criminal charges pending against you right now?
Nothing but this one.
Sorry?
Nothing but this one.
Okay. If a prison sentence was imposed in this case, upon your release from prison, you could be placed in what we call post-release control. That's sometimes referred to as parole. What that is, it's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes, sir.
If you were on post-release control and you were violated any of the conditions of your supervision, we would have a hearing to see if what's called a probation, that's a probation violation. This is for parole. If you were on post-release control and you were violating the conditions of your supervision, the parole authority would have a hearing. If they found you violated, they could send you back to prison as punishment for violating the rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of the prison term imposed by the court. Do you understand that?
Yes, sir.
All right. Now, aside from this possible prison sentence I just mentioned, there are other sanctions that could be ordered. You could be fined in this case up to a $10,000 fine. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable in this case. Do you understand that?
Yes, sir.
You could also be or will be ordered to forfeit any ownership interest you have in that firearm and the ammunition at the time of sentencing. It's due to the forfeiture specification. You understand that?
Yes.
All right. Now, a few moments ago, I explained the possible prison sentence. I used the word possible. Prison's not mandatory with this charge. You are eligible for probation, or what is referred to as community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't automatically mean you get probation or be put on probation, but it means I would consider that. I'll look at all the evidence presented, and I would make the decision ultimately that I thought was the right thing to do. Do you understand that?
Yes, sir.
Now, if you were put on community control sanctions, it could be for up to 5 years of supervision. And as the judge, I would have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes, sir.
Further, if you were on probation and you ever violated any of the conditions of your supervision or the rules of probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did it at that point, again, it could be 9, 12, 18, 24, 30, or 36 months in prison. You understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you'll have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer can speak on your behalf and recommend the sentence to court. The prosecutor also has a right to recommend the sentence to the court. Do you understand that?
Yes, sir.
You understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all regarding the potential penalties you face by pleading guilty here?
I understand, sir.
Do you have any questions regarding the potential penalties that
No
you
questions,
face by
sir.
pleading guilty here?
No, sir.
So you understand all the possible consequences of what could happen in sentencing?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to talk about this case with Mr. Matthews and have him review the reports with you and answer whatever questions you have?
Yes, sir.
Are you satisfied with his advice and counsel?
Yes, sir.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, then, do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, the penalties you're facing, what you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to speak with your lawyer before we go forward with your actual plea?
No, sir.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to what she says, because I'm then going to have some follow-up questions for you, all right?
Yes, sir.
All right, let's go for the state.
Thank you, Your Honor. The facts would show that on November 3rd, 2024, in Mentor Lake County, Ohio, officers conducted a traffic stop on a vehicle that the defendant was driving and gained probable cause to search the vehicle. During the search, officers recovered a loaded Tanfoglio TZ 75 9mm semi-automatic pistol, which was determined to belong to the defendant. It was taken to the Lake County Crime Lab, tested, and determined to be and found to be operable. At the time, the defendant had been previously convicted of aggravated assault, a felony of the 4th degree, in the Cuyahoga County Court of Common Pleas, case number CR-1-408424-ZA, dated October 31st, 2002, as well as domestic violence, a felony of the 4th degree, and the Cuyahoga County Court of Common Pleas, case number CR-10-540204, dated October 29th, 2010.
Thank you. Sister, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if it went to trial in this case?
Yes, sir.
What, if anything, do you have to say about those facts as she presented them? Are those facts true? Did you do what she said?
Yes, sir.
Very well, then, regarding count 1, charged with having weapons while under disability, a felony of the 3rd degree with the forfeiture specification. What is your plea to that?
Guilty, sir.
All right, I have in my possession here at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you.
Yes, sir.
Before I can accept your guilty plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is before I came out here on the bench, you had a chance to go over that document with your lawyer. Is that correct?
Yes, sir.
Mr. Matthews, is that accurate? Did you review this with Mr. Cuthbertson and answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you went over it with him?
He did.
Is that correct, sir?
Yes, sir.
So you understand what this document says?
Yes, ma'am. Yes, sir.
Do you have any questions for me about what it says?
No, sir.
Now, it appears that you signed this document. Did you sign it before I came out here?
I understand.
It appears that you signed this document. Did you, in fact, sign it before I got
Yes,
out
sir.
here?
Yes, I did.
Mr. Matthews, you witnessed that?
I did, Your Honor.
Ms. Gold, you as well?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Finding the defendant guilty of count 1, having weapons while under disability, a felony in the 3rd degree in violation of 2923.13A2. Count 2 will get dismissed. Also, find him guilty of forfeiture specification. Count 2 will be dismissed. The first sentencing order, pre-sentence report investigation. Anything else you're requesting, Mr. Matthews?
I don't believe that we're asking for a drug and alcohol evaluation, but at some point in this, Mr. Cuthbertson did want the court to know that it is very likely he will test positive for marijuana. He and I discussed this back in my office, and he has not used recently, he's indicated to me, but he did want the court to be aware of that possibility.
But you don't need but there's no issue with drug or alcohol?
Only marijuana, Your Honor.
Only marijuana. He wasn't supposed to use marijuana. He apparently used it while he was on bond, so he couldn't comply with the rules of probation, or he said didn't care about the rules of probation, one of the two. I'll order drug and alcohol evaluation as well. Continue. taking your bond today. I haven't tested positive for anything at this point. What's going to happen at this point, Mr. Cuthbertson, will continue your bond as you sit here right now. One of the conditions has been, is going to continue to be that you don't use any drugs, which includes marijuana. You have to provide urine screens. If they should be positive, your bond will be revoked and a warrant be issued. Do you understand that?
I didn't hear you, Your Honor.
I'm
I'm
continuing your bond today at this point. However, one of the conditions of your bond has been and will continue to be that you don't use any drugs, which includes marijuana. You may be requested to submit urine screens. If they should come back positive, your bond could be revoked and a warrant would be issued for you. Do you understand?
Yes, sir.
So you're going to leave here right now. You're going to go to the probation department. You're going to set up a time to come back. They need to interview you before they can prepare a report. So you're going to have to come back and meet with them. When you talk with them, you need to be open and honest with them because they're going to check and verify everything you tell them. If they learn you're misleading them, they certainly will let me know that. If you don't show up when you agree to come in with them for this interview, then they can't complete a report. Without a report, I can't even consider probation as an
Right,
option.
yes, sir, I
It's
understand.
important you show up when you're supposed to. Now, I understand you don't have a fixed address, is that correct?
I understand what you say.
You don't have an address, a fixed address that you live at?
Yes, yes, sir, I do.
Well, why was I advised that it wasn't?
I believe the address is a mailing address, Your Honor.
Well, that's not what I asked him. I asked him,
I
does he have a
understand.
fixed address that you live at?
Yes, sir, yes, sir.
Then
I'm
why
sorry.
was I told that he did it?
I'm sorry, I understand.
Where do you live?
I stay in my car.
Okay. And does your car stay the same? So then what's your fixed address that you live at? You don't have one.
10804 Governor Avenue.
So that car's there all the time?
Most of the time, yeah. I sleep in the driveway.
Okay. So you don't have a house that you live in?
No, sir.
So you don't have an address that you live at?
No,
You
sir.
live in your car?
Yes, sir.
Which is fine. What I'm trying to get at is you don't have that mailing address isn't for a house that you live at, right?
No, but that's where all my mail goes, sir.
Well, here's the deal. You need to make sure you have all of your future court dates. And you've been here, you were at your pretrial, you're here today. If you don't show up, there's not gonna be any excuse that, well, that's just a mailing address, I didn't get notified. It's your responsibility to
I'll
make
be
sure
here.
you know when your court dates are, what time they are, and to be here for that. That's all
Yes,
I'm
sir.
trying to stress here.
Yes,
all right?
sir.
I mean, if you live in your car, I get you live in your car, but it's your responsibility to make sure you keep in touch with your lawyer. It's not his responsibility to make sure he keeps in touch with you.
I understand, sir.
You need to make sure you know when the dates are, so you have to make that effort. That's all
Yes,
I'm
sir.
trying to stress here.
Yeah, I get my mail all the time.
Okay? Well, you've been here, and I get it, so I'm not questioning that. Make sure you go to probation when you leave here right now. Anything else for the record then?
Nothing from the state, Your
Mr.
Honor.
Matthews?
No, Your Honor. Thank you.
All right. We are present case 24 CR 460, State of Ohio versus Nathan Starkey. We are here for a scheduled final hearing on a motion to terminate community control sanctions that was previously filed. Defendant is here in court. He's with counsel, Ms. Rachel Smith. Ms. Smith, what is the defendant's intention at this time regarding the final hearing?
Thank you, Your Honor. At this time, it is Mr. Starkey's intention to enter a plea of guilty to the violation and proceed with mitigation and sentencing.
Thank you. Mr. Starkey, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated Rule 8, which prohibits you from using or possessing or having under control any controlled substance not prescribed to you by a licensed physician. And it's alleged on February 20th, you submitted a urine screen that tested positive for alcohol, amphetamine, methamphetamine, cocaine, and ecstasy. Now, you have the right to have what we call a final hearing regarding this allegation, which is a hearing where the state will be required to prove the merits of what they're alleging. You could have that hearing, but you can also waive the hearing and admit to the violation. Your attorney has indicated she believes you want to waive the hearing and admit to the violation. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your remission or plea, I need to make sure you understand the potential penalties you face if you're found to have violated your community control sanctions. If in fact that did occur, the court could continue on community control sanctions. I could extend the community control to 5 years. It was originally, I think, 3 years, so I could extend it another 2 years. I could impose more restricted sanctions against you, or I could terminate your community control and send you to prison. If I did that, it could be 6 to 12 months on each count. I can run those sentences consecutive to up to 2 years in prison. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have, excuse me, the final hearing, or do you want to waive the hearing and plead guilty to the violation?
I'd like to plead guilty, Your Honor.
Very well, then that's the allegation you violated Rule 8 by testing positive for alcohol, methamphetamine, cocaine, and ecstasy. What is your plea to that?
Guilty, Your Honor.
The court will accept your plea, find that you did violate your community control sanctions. Ms. Smith, any reason not to proceed with sentencing?
None that I'm aware of, Your Honor.
Anything you would like to say at this time on behalf of your client?
Yes, Your Honor. At the time of his probation violation, or prior to, Mr. Starkey was engaged in his recovery journey. He had obtained full-time employment and was working at Mary's Diner. He was about halfway through intensive outpatient treatment at that time, and he has been very forthcoming about his relapse. One thing that Mr. Starkey will not be doing when he if the court should release him and place him back on community control, is he will not be returning to employment at Mary's Diner. He understands that part of the reason that he relapsed was that the people that he was working with were getting high. That provided access for him, and when a coworker gave him some substances, Mr. Starkey then went on a 2-day bender. He recognized the issue, went to detox, reached out to his sponsor, but he understands that right now he does not alone have the tools to overcome his addiction, and is asking the court for an additional opportunity at inpatient rehabilitation in order to develop those tools. Thank you.
Mr. Stark, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say?
I'd just like to apologize to the court. I slipped up, but I really would like a chance to continue doing treatment. I learned a lot while I was at square one in that 30-day residential there, and I would like to continue getting treatment. I feel like it was very beneficial for me. I learned a lot. That's what I'm hoping to do. Just apologize again.
Well, this court has reviewed the original pre-sentence report investigation. I've considered the facts and circumstances of the original underlying offenses that brought us here, the nature of those offenses. I've considered the defendant's probation, his performance on probation. I've considered what's been said here in court today. Ms. Smith, as well as the defendant himself. All this is considered in light of purposes and principles of felony sentencing set forth in 29-2911 of the revised code. Now, as for the factors in 29-2912, I will incorporate all the findings I made at the original sentencing hearing regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has failed to comply with the previously imposed sanctions ordered by this court, and he did so rather quickly after being put on probation and released from jail. But those are factors, and that's a factor indicating recidivism is more likely. You know, Mr. Smith, you've been to prison 2 times at least. Last time you got out wasn't that long ago. But despite that, I gave you an opportunity here, and within, I don't know, how long after you got out of jail did this happen? A couple months?
I got out.
Got out December 14th. And within at least a couple months, if not sooner, you're back here, you violated. We're back for a probation violation now. When did you start IOP?
As soon as I got out.
Where were you doing that?
Signature Health.
So this place, the restaurant's the same place I let you work at for 4 months while you were in jail.
And the whole time that I was been there, everyone was still getting high. People were at work getting high, and I didn't think it was going to be an issue until I had a bad couple days. We lost our pet, and then I had another job lined up that I had got hired at. I started on my first day, and then the second day after work, the boss came to me, and my background check came back, and they said I looked like a repeat offender because of my background, and they let me go. I was still at Mary's, and the next day, I was just kind of having a bad day. And without even asking, one of the workers there put a bag of meth in my pocket, of my hoodie pocket that was hanging up, and told me they put something in my hoodie pocket, and I couldn't
In
stop
your what
thinking about
pocket?
it. My hoodie pocket that was hanging up, like, in the employee area. And then after it was like in my possession, I couldn't say no. I was like, I just
couldn't
kept thinking.
say no?
I kept thinking about it all day.
Why couldn't you say no? Why'd this person just give you drugs?
They thought it would help me or something. I don't know. Probably
So
wanted-
he had known that you were
They
feeling
knew I was on
down or
probation. They knew
bummed or whatever the case may be. What about your girlfriend? 'Cause last time you were here, it was because you and your girlfriend are both using. Assume she's still using. I'm not sure what kind of influence
Once-
that is.
Once she saw that I was high, because I couldn't hide it when I came home, we got into an argument. She ended up getting high with me, and we both got high for like 2 days, and then we went to detox.
You went where?
We went to detox.
Detox.
Then I signed the ROI when I got to detox. I called Kim as soon as they let me. The dirty urine screams from when I went to detox.
I understand that. The problem is when we were here last time, I was having this debate in my head whether you should be going to prison or not then. With your history. I gave you a chance and then within 2 months you violated it. Community control for 3 years. How's this going to last 3 years? If I give you another chance here. It doesn't last 2 months. Well, I will give you an opportunity. I probably screwed up last time in letting you keep your work and job and work release and not making you get treatment then. Everybody tells me I'm better now. I haven't used, and I shouldn't have gone along with that. I will give you one last chance here, Mr. Starkey. I will find that you're still amenable to an available community control sanction. Continue on community control sanctions. It was originally 3 years, right, Kim?
Yes, Your
I'll
Honor,
just leave it at that.
that's correct.
How much credit is there on the TV? I think you said 20-something.
22 days, Judge.
When is this bed available? Roughly, I mean, Kim, do you know? Kim?
Excuse me?
I'm sorry. Do you know when that bed's available, or roughly?
Well, it's a,
I know
I
they.
was told that there was beds available right
Well,
now.
this is what I'll do then.
Yes.
I'm going to order 40 days in jail with credit for 22. Should be able to get in within the next 18 days, you assume?
Oh, I would definitely say
So
so.
40 days in jail, credit for 22. It will allow him to be released I'm going to order him then to enter and successfully complete the treatment program at either Lake House or Concord Pines, whichever has a bed available first. Once that bed's available, he can be released from the jail. Any balance of the 18 days will be vacated. So, I mean, if there's a bed available tomorrow, you can leave tomorrow. If it's not for 10 days, you'll have to wait 10 days. Whenever that bed's available, you can be released at that time. You'll be transported there by your office, Rachel, or probation?
Myself,
Probation
yes.
will transport you there. And again, any balance of the jail time will be vacated. You need to successfully complete that program, follow all their aftercare recommendations. And you need to comply with the basic rules of probation at that point. No drugs or alcohol, with marijuana, submit random urine screens. They have to be negative. 3 AA meetings a week, have a sponsor, maintain full-time employment. Mental health. Did you get your mental health evaluation or not?
Yes.
Do they recommend anything?
They put me on Zoloft and Trazodone.
What about any type of counseling?
No, I didn't get any personal
recommend
counseling.
anything?
No. I had a follow-up appointment that I missed while I was in residential.
Well, let's follow up with mental health evaluation and follow up recommendations for any type of counseling that may be appropriate. Take any prescribed medications as prescribed. I assume you didn't get your driver's license yet.
I got my driver's license back.
When did you do that?
I paid the fines while I was on work release.
Was that all it was?
I had 2 tickets, one in Mentor and one in Painesville that I had to
So
pay.
you have a valid license right now?
Yes.
Okay. That's good. That's what I have then. AA meetings, employment, mental health evaluation, and follow recommendations for counseling. Take all your medications as prescribed. Kim, is there anything else that you think of that we should consider here?
No, Your Honor.
Decision points, anything that we should consider, or?
He can do decision points,
I mean, it wouldn't start until after.
yeah, and so if he's, usually I like to recommend decision point if they're doing JTP
Okay.
in the jail, they can
I
do
won't
it
do that.
together.
I won't do that then.
Okay.
I guess they could start it immediately, but they can't do that here. Pay court costs and supervision fees. All right, Mr. Stark, you understand the conditions of your continued community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I do need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while on probation, another motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could, again, continue on probation, extend it up to 5 years. I could impose more restrictive sanctions against you. Or I could terminate your community control sanctions and send you to prison. If I did, it'd be 12 months on each count consecutive. And that's where we would be at that point. With the history, with it being a second violation, that's what you're going to, the position I'm going to be in at that point. You understand that?
Yes, Your Honor.
All right. Any questions?
No, Your
All
Honor.
right. Ms. Smith, anything else for the record?
Not at this time, Your Honor.
All right, thank you.
All rise.
That's what I say. And we're here in case 24 CR 435, State of Ohio versus Malachi McDougal. We are here for a final hearing on a motion to terminate community control sanctions. Been previously waived probable cause. He's here at this time with his attorney, Ms. Culotta Ragazian. Ms. Ragazian, what's the defendant's intention at this time regarding the final hearing?
Thank you, Your Honor. Mr. McDougall will waive the final hearing. He will admit the violations, and we would ask to be heard as to sentencing.
Thank you. Well, Mr. McDougall, you have been charged with violating the conditions of your community control sanctions. Specifically, there's two alleged violations. The first is a Rule 3 violation, which requires you to report to your probation officer at times and places as directed, and specifically allege that you failed to report as you were scheduled and directed to do so both on March 12th as well as March 19th of 2025. It's further alleged that you violated Rule 10 by not providing a urine sample as directed to on March 21st, which Rule 10 requires you to submit random urine screens as directed by your probation officer. Now, you have the right to have a final hearing regarding these allegations. The first is a hearing, this hearing is a hearing where the state of Ohio will be required to prove the merits of what they're alleging. Now, you could have this hearing, but you can also waive the hearing and plead guilty to the violations, and your attorney has just indicated she believes that's what you want to do. Is that correct?
Yes, Your Honor.
Before I can accept your plea, I need to make sure you understand, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to, well, I gave you the maximum, 5 years, so I can't extend it anymore. But I can continue on community control sanctions. I could order that you, order you to more restrictive conditions or other conditions that I think are appropriate, or I could terminate your probation and send you to prison. If I did that, it could be 9, 12, 18, 24, 30, or 36 months in prison. Do you understand all the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violation?
Waive the hearing.
Very well, then as to the allegation that you violated Rule 3 by failing to report to your probation officer as directed on March 12th and March 19th, what is your plea to that?
Guilty.
As to the allegation you violated Rule 10 by not submitting a urine sample as directed to do so, what is your plea to that?
Guilty.
The court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Gaziano, any reason not to proceed with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor, thank you. Your Honor, in speaking with Mr. McDougall, as well as the conversations that we had in chambers and with probation, it does sound like he was explaining in various ways what had happened, why he missed probation, why he didn't provide a screen. And it was apparent that there was something else going on, something more to the story. I have spoken with Mr. McDougall, and he has admitted that he relapsed. He was overwhelmed, he was scared. That was why he missed probation. He basically, rather than initially owning up to the situation and admitting not only to everyone else, but I think most importantly to himself, that he did have this mess up after he had been doing well and enjoying AA. He instead tried to kind of weave this whole story, and he recognizes that that is not the approach he should have taken. He is seated here today before you, very contrite about this situation. He feels like his relapse spun out of control. He told me he ended up, after that relapse, using pretty much continuously for about a week. And he recognizes that he should have just owned up to this right away, Unfortunately, he did not do it right away, but he is here doing it now. He does have a lot of support in his life. He has numerous people, as Your Honor can see, that are seated here in the courtroom that are showing up for him today. I do believe some support letters were submitted on his behalf. And really, he was enjoying his sobriety. He felt he was doing well. He was enjoying going to meetings. And unfortunately, a temptation presented itself, and he fell back into that old pattern. And then he made it worse by trying to cover it up with these various stories. However, he also recognizes that these are thinking errors. He wants to address those thinking errors. He wants to address his substance use, and he is asking this court for one more chance to do that. He is asking this court to give him an opportunity at NeoCap. That is a program that could help him address those thinking errors as well as the other issues he has going on with substances. So I would ask the court to find that he does remain amenable to community control sanctions in this matter. Thank you.
Thank you. Mr. McDougall, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes.
Go ahead.
I just messed up. I was doing really well.
You what?
I was doing really well with school and stuff, and started getting overwhelmed. And I hung out with somebody in aftercare who relapsed.
Who was that?
Carl.
Carl?
Carl Stahl. Yeah.
Stahl?
Yeah.
Good.
And he had stuff on him, and he was high, and it tempted me, and that's just what happened. I ended up relapsing for like a whole week, and
When was that? Do you remember? In relation to when you were supposed to go to
it
probation?
was in between the first meeting and the second meeting. So,
Whoa, whoa, whoa. You showed up on March 6th with a letter from a doctor that you had
Right.
gone to the doctor that day.
yeah,
I don't know why you showed up with the letter, because you showed up to probation, so I don't know what the purpose of the letter was, except unless you were trying to get out of having to go to aftercare that night. And then on March 12th, you didn't show up. And then on March 19th, you didn't show up.
So it was March 12th.
yeah, it was around March 12th. March 12th is around when I relapsed.
Okay.
I met up with Carl, and we ended up using together. And then I was embarrassed. I was lying to my family. You know, they knew something was wrong, but I was lying to everybody. And I was lying to myself. I was disappointed in myself because I was doing really well.
So why do we have to go through this whole charade for the last 3 weeks or whatever it's been? Everybody knew.
I know.
I knew. They knew, apparently.
I know.
Everybody, you must think we're idiots if you think we can believe the stories that you were saying, because they made no sense. That defied common sense.
I was just embarrassed. I'm disappointed in myself because I know I can do better. I was doing so good. You know, I was in school full time, and I just got overwhelmed and made a
Where
bad
were you going to
decision.
school?
Hamrick truck driving school.
How far were you along there?
A month and a half,
When did you start?
end of January.
That's for like a CDL?
Yeah, Class A. And I was going Monday through Friday. I had to drive out to Medina, and I was only working every other weekend, so I only had a couple $100s.
Where were you working? Still at the nursing home?
Yes, sir. And I was doing good, man. I was doing my schooling. I was doing my meetings on time, and it was just one bad decision, man.
So what happened? How'd this happen? I mean, you said
Carl relapsed. We were in aftercare talking about it. He came back, and then the next day after aftercare, he hit me up and asked if I wanted to hang out. And I was like, why not? I was trying to be supportive of him because he relapsed.
you
know?
knew he relapsed?
Yeah, he told everybody in aftercare he did. So I was just trying to be supportive of him, you know. And he got in my car high. He was high, and it triggered me, you know. And it was just one bad decision, and then I ended up kicking it with him for a whole week. lying to my girlfriend, lying to my aunt. I'm just so disappointed because I was doing really well, especially in AA. I had a key to the church to open up for my home group. And I enjoy that stuff. And I was just embarrassed. I am embarrassed still, you know. For once I was enjoying my life, you know. I was on good terms with Cindy, and it felt really good. And I just messed up. I messed up everything. And on top of it, I couldn't even own up to it. I lied about it and tried to make up a story, knowing that Cindy knows me. She knows me, and she knows that something was wrong.
Well, I mean, she does, and Cindy's great at what she does, but you've all been doing this I've been doing this for 35 years, everyone's been doing that. I mean, but even someone that hasn't been doing this knows that story doesn't make any sense. It doesn't have to be, I mean, the story you're putting out there doesn't have to be someone that has all the experience Cindy has, quite frankly.
Right.
It didn't make any sense. Cost you 2 or 3 more weeks in jail, to be honest with you. Is there anything else you want to say?
I would just like to have one more shot. I know what you said in sentencing last time. I just want one more shot. I know I can do this. I know I can stay sober.
And I put you on probation for 5 years.
Yeah.
You made it 3 months after you got out of jail. Right? We got out in December?
Yes, sir.
Or no, he got out of
Yes.
the residential house, not jail, I'm sorry.
Yeah.
In December. Within 3 months you violated it. I mean, you're going to be faced with temptation and stress and, you know, stressful situations for the rest of your life, quite frankly. But while you're on probation, you're going to need to handle it, deal with it. Mr. Graziano, anything else you want to add?
Your Honor, I just think that based on what Mr. McDougal has expressed, it does sound like he has thinking errors. I know he's been accepted by NeoCap as an acceptable candidate, so I would ask the court to consider that for him and to allow him that opportunity. Thank you.
So if I send you to NeoCat, Mr. McDougal, you're going to put forth the effort that's needed there? I mean, it's
Of course.
what do you say, of course. It's a lengthier program. Now, maybe you were wanting to go there because you just would have had to admit this. But you're going to be there for a while. It's a you know, you're locked in there. It's a good program, very good program. But you're going to have to you're not going to get anything out of it if you don't put forth the effort there and want to be there and avoid the negative influences that are there. There's people there that right now that are just there because it was either they agree to that or they go to prison. They don't want to go to prison, so they're going there. And it's a similar situation to what you're in. But if you don't go there with the right attitude, you'll complete the program, but then you're going to get out and be on your own, and you're going to relapse with Carl within 3 months again, or someone like Carl. And there's going to be people there that are like that aren't putting forth the effort, don't want to be there. And you're going to be very negative. And you just got to isolate yourself from them, separate yourself from them. Or you're going to be one of them. But it's not going to work if you are one of them. You're going to do what you need to do to complete this and get something out of it and
Yes, Your Honor.
help with the thinking errors that your lawyer talks about, along with everything else that it can help you with?
Yes, Your Honor.
All right, well, I've considered everything that's been presented here. Facts of the original case, history and probation. I know I said I wasn't going to do this, but I'll give you one last chance, Mr. McDougal. You're charged, you got a huge break to begin with in this case. You were charged with a felony of first degree, mandatory prison. Prosecutors reduced it because of how you presented yourself and what was going on. I went along with probation. I still question myself whether I did the right thing then. Now I'm going to do it again, but this will be it. I know I may have said that last time, this will be it'll be the maximum sentence next time. If I shipped you today, it probably wouldn't have been the maximum sentence, to be honest with you. I would have reduced it. But I won't next time. I find that you're amenable to an available community control sanction. The prison is not consistent at this point, the purposes and principles of sentencing. You're going to continue your probation for 5 years. See, I know I asked you this a couple of times. What is it, 20, how many days on the PV?
27, Your Honor.
27 days. What's the wait right now? You have any idea?
I think mails are getting in pretty quickly.
Yeah.
Yes.
All right, I will I'll order 60 days in jail with credit for 27 days. That should be enough, right? 33 days.
Yes, Your Honor.
I am going to order that upon a bed becoming available at NeoCap, that you be released from jail to enter NeoCap and can successfully complete that program. Any remaining jail time of the 60 will be vacated. I'm then going to order that you successfully complete that program, follow their aftercare recommendations. Upon completion of NeoCap, I'm going to order, and you're probably not going to have to do this, but I'm going to put it in order in place for every NeoCap case, that you return to jail for 30 days in the transitional day reporting program. That's a program that helps people make the transition from being locked up to being on their own. Some people don't have anything when they get out. They have no place to live, no place to go. So this is a nice program that helps people make that transition. But at the end of NeoCap, if you've got a place to live, you've got work lined up, and you're ready to get back to what you were doing, I'll vacate that 30 days. You won't have to do it.
Okay.
But it's a good program for those that need it, so I put it in place for everybody. At that point, then, the conditions of your probation are going to be pretty much what they were. No drugs or alcohol, random urine screens, have to be negative, 4 AA meetings a week with a sponsor. Are you doing any type of medically assisted treatment? I know you're supposed to be assessed for that.
No, I was gonna do the Vivitrol shot, but the trial made me feel weird, so I didn't want to get put on Suboxone. So
you were assessed for that, though?
yeah.
Maintain full-time employment or education, training like what you're doing as well, but full-time, keep them busy working or going to some type of schooling. Whatever happened with the mental health evaluation? Were the recommendations that were made?
Same thing, they tried medication with him, he couldn't tolerate the medication, so they discontinued.
No type of counseling or treatment, though?
No.
Okay. One doctor, one dentist, one pharmacy. Take any medications as prescribed. If there are any, pay your court costs and supervision fees. No contact with Carl Stahl. Cindy, anything else that we should consider here?
No, Your Honor, thank you.
I'm sorry?
No, Your Honor.
Mr. McDougal, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. Well, all right, it is 5 years again, I'm sorry. I can continue on probation to finish up to 5 years. I could impose more restrictive sanctions, including local jail time, or I could terminate your probation and send you to prison. If I did it, it would be 36 months in prison. That's what it'll be. And that could be consecutive to any other sentence you may be serving at that time from some other case, or that you, for any new case, if you were to pick one up. Understand that?
Yes, sir.
All right. Mr. Gazione, anything else?
No, Your Honor, thank you.
All rise. so it's not open.
We're here today in the state of Ohio versus Rebecca Franks, case number 24CR998. The defendant is present with counsel Chad Mulkey, and we're set today for a sentencing hearing. We were last before you on the 3rd of this month where the defendant changed her plea. She pled to one count of aggravated possession, a felony of the 5th degree with a forfeiture specification. A pre-sentence report and drug and alcohol were ordered and have been completed, and the defendant has 4 days of jail time credit. Thank you.
Thank you. Mr. Mulkey, any reason not to go forward with sentencing?
Not at all, Your Honor.
Anything you care to say on behalf of your client?
There is, Your Honor. Thank you. Please, the court counsel, others in the courtroom. My client is 43 years old. She has 3 children. She has recently moved to Ravenna, Ohio. She lives at 875 Jones Avenue. She lives there with a Sean Davis. She indicates to me he has no record, Your Honor. As it relates to her criminal history, she has a couple misdemeanors out of Ravenna and Stowe Municipal Court. Prior felony for aggravated possession in Summit. She's currently on supervision regarding that matter through Summit County Adult Probation with a probation officer named Twanisha Mitchell. Now, my client indicates to me that she, as part of that condition of her community control there, she receives a text every morning around 5:30 a.m. She has to respond by 11 to decide whether she has to go in person for screens. My client's indicated to me she's been testing negative. Per those requests, I asked her when she received her last text. She said it was this morning around 5:30 a.m. So she's been doing well on that. She meets in person with her probation officer there 1 time per month, Your Honor, and she indicates things have been going well. She further indicates that she has gotten involved with a virtual counseling called Work at Health Ohio. She last had a meeting there on Thursday, April 10th. It is virtual. She furthermore indicated to me that she is in the process of enrolling in a program called Stepping Stones in Ravenna. It's a drug counseling center. Her probation officer indicated that that was an acceptable place to start her treatment, Your Honor.
What treatment?
I believe it is in relation to her ILC program from her aggravated possession charge in Summit with Judge Allison Bree, Your Honor. So I think that's what the treatment would be.
Isn't that like 5 years ago or something like that?
That case was from 2021, Your Honor. So you can inquire of her with more I don't have much more detail than what I saw in the report from her.
No, she was just granted intervention a couple months ago. I don't know what happened for 5 years.
Right. As for her substance history, there is opiate use there. She indicated to me that she does want to get help for her substance abuse so that this does not become a reoccurring or a continuing problem. Therefore, Your Honor, based on the actions that she's taken and the steps that she wants to take in the future, she would like to become and remain a productive member of society. I'm sure the court's probably going to order her to maintain verifiable employment. She had indicated to me that she has an internet business buying and selling things, Your Honor, but she would comply with the court's orders regarding employment and, of course, any and all other court orders and supervision conditions. So we'd ask the court to not place her in the local county jail at this time, nor send her to prison. I think she'd be an excellent candidate for community control. She was timely here on court today. She has produced negative negative screens when she was briefly taken into custody a few weeks ago. So with all these factors taken into consideration, we ask the court to overcome any to find in favor of community control and not send her to prison and not impose any additional actual incarceration on her at this time. Thank you.
Thank you. Mr. Franks, you have the right to address the court before you are sentenced. You can say anything you want. Is there anything you care to say at this time?
No, thank you, sir.
So I don't get why you take Suboxone. Why don't you explain that to me?
I used to be addicted to opiates, and it's a treatment for that.
I know what Suboxone is a treatment for, but when were you last using opiates?
It's been years. They gave me opiates when I was in the hospital for when I was burned, but I haven't taken.
Oh, that was recent, but
yeah,
you're claiming. I'm assuming if you're taking Suboxone, you were addicted to opiates at some
yes.
point. When?
I don't remember the exact dates, but it's been probably 10 years.
So why are you taking Suboxone now? 10
I
years
have
after.
a physical dependency on it.
So you're addicted to Suboxone.
Mm-hmm.
Isn't that a drug that you're getting addicted to? Hey, that makes sense to me.
Can't be, Your Honor.
So you're addicted to Suboxone. You need Suboxone.
Yes.
You've been taking that for like 15 years or so, it looks like. Is that right?
Mm-hmm. I didn't realize it caused that kind of physical dependency when I began taking it. I wish that I hadn't, but here we are.
Well, you need to break that. You need to work on that. Mr. Mulkey, anything else?
Your Honor, I did speak to her about an outstanding traffic warrant as well. She would like to take care of that. And it should be pretty easy for her to do since she has now moved to Ravenna and the bench warrant is out of Ravenna on a traffic matter in 2023. It looks like that's the case number 23 TRD 84. Your Honor. So other than that, I have nothing further.
Why is that still out there?
I had forgotten about it when I was ill.
When were you ill?
When I was I was burned and I was in the hospital in the ICU for over a month, and then with therapy and everything after that.
That's the result of this incident, right? That's
Yes.
what this incident was about, when you got burned.
Mm-hmm.
All right, well, that's July 31st of 24. It was a year and a half after you didn't show up. You were supposed to show up in court in January of 23 for a court hearing.
Yes.
And then this incident didn't occur for a year and a half later.
It was.
You can't blame this incident for not showing up to court and having a warrant out for you for so long.
I'm not blaming it on anything. I had
hard time
forgotten it.
hearing you.
I'm sorry, I forgot about it. I was living an hour away, and I don't know.
I don't know how people forget about warrants. If I have a warrant out for me, I'd be looking over my shoulder every time I step out the door. You just blew it off, is what you did. Ms. Belford, State of Ohio?
Thank you, Your Honor. I had the opportunity to review the pre-sentence report in this case, and I know that was prepared when this case we thought was going the intervention way. But the defendant has pretty limited criminal history. That warrant certainly is troublesome to the state. However, the state does believe that community control is appropriate in this case, and the state would just recommend that that includes some sort of in-person treatment. Thank you.
This court has reviewed the pre-sentence report and investigation. There was a drug and alcohol that was prepared as well as part of the intervention in lieu. Considered that. And I've considered the facts and circumstances of this case, the nature of the offense involved here, the whole history of this case. I've considered what's been said here today by the defendant, the lawyer, the prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, nothing indicates it's more or less serious. As for the recidivism factors, the court notes the defendant does have a history of criminal convictions. This is the first, hang on. Technically, it's her first felony. She had a felony arrest and charge in Summit County that she is on intervention in lieu of conviction for, and she was actually on intervention in lieu of conviction when she committed this offense. Despite that, apparently they did not rescind that there, and she's still on intervention in lieu of conviction. I'm confused about the timing. The incident for that occurred 4 years ago, 3.5 years ago. What took so long there, but apparently there were some warrants out for her for some time. Oh, for a long time. Well, what was the problem there? You go to court. Forgot about it?
No, I didn't forget about it. I had 3 different attorneys, and two of them withdrew. It was an overwhelming and traumatic experience, and I didn't know how to handle it very well.
You just blew it off?
I wasn't trying to blow it off. I didn't know what to do.
How would you not know what to do if you're supposed to be in court? Go to court. That's what you're supposed to do. When did this intervention plan that she, or well, I shouldn't say it, that prior to that, she just had multiple failure to appears. Those are factors indicating recidivism is all more likely. Nothing indicates less likely. Under 29-29-13B1, again, the court finds the defendant was on bond at the time to Summit County Common Police Court when she committed this offense. Despite that, the court finds prison at this time in this case would not be consistent with the purposes and principles of sentencing, and the defendant is amenable to available community control sanctions. So I'm going to place you on community control sanctions for a period of 2 years. I'm going to order that you serve 4 days in jail with 4 days of credit. I'm going to further order that you do not use any drugs or alcohol. You must submit random urine screens. They have to be negative. A positive screen is a violation. To attend 3 AA meetings a week and have a sponsor. I want you to immediately enter an intensive outpatient treatment program. You're not going to be doing anything virtual for this court at least. If our court accepts that, you want to do that there. This is going to be in-person treatment that you're getting. An intensive outpatient treatment program in person. Just complete that program, follow their recommendations. And that needs to begin immediately. I'm not giving you jail time, so that needs to get done right away. You're also to obtain and maintain full-time employment, verifiable employment. Do whatever you're still doing if you want, but that's not going to count as your employment, just selling stuff on Facebook Marketplace. You need to get a job. I also want you to resolve this outstanding warrant immediately. That's the only reason you don't have a license right now, right?
Yes.
So once that gets resolved, you'll have a driver's license.
Mm-hmm.
Doesn't that make life easier?
Yes, it does. I'm going to do it.
Well, why would you put that off?
I don't know.
All right, well, get that taken care of. That's going to make things a lot easier for you. So you need to resolve that warrant immediately, then obtain your license, get a valid license. To obtain a mental health evaluation, follow whatever recommendations are for any type of counseling. You see one doctor and one dentist. If you have a specialist, that's fine too, but that can give you medications. You can see more doctors, but you can only get prescriptions from one doctor and one dentist and any specialist. Whoever you get prescriptions from, probation needs to know who those doctors are. You don't get them from them. You can only fill them at one pharmacy, and they need to know where that pharmacy is as well. Need to sign whatever releases they may need, so that if they need to contact those folks, they can do that. Pay court costs and supervision fees. I'm going to order the forfeiture of the contraband and instrumentalities and the specification. Jamie, anything else I should be thinking about here, considering?
I just want to clarify with the mental health treatment, that should also be in person?
Yes. We're not doing virtual stuff.
Thank you.
Thank you. I take all medications as prescribed as well. So Ms. Franks, you understand the conditions of your probation?
Yes, sir.
You have questions for me?
No, sir.
Need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, if you commit a new offense while you're on probation, and I don't care about this driving under suspension, that's not going to count. I mean, it's not going to hurt you for your probation. It's something that happened in the past. So you resolve that however you need to resolve that. If it ends up that you plead guilty to it, or convicted of it, whatever's your best interest, that's not going to violate you here. Talk about new conduct. If anything like that should happen going forward, a motion to terminate your community control sanctions will be found. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months in prison. But I can assure you, if you violate, there's going to be a warrant issue for you. You're going to get arrested and sit in jail, and you're not going to get out of jail immediately like you did this past time until we resolve that. And it's going to take some time. And then, depending on the nature of the violation, you very well could be going to prison. You understand that? So if there's stuff here that overwhelms you, or you have questions, you don't know what to be doing, you need to contact the probation department. That's what they're there for. I'm not gonna buy any of these excuses that you didn't know what to do, you were overwhelmed, you were stressed, and then you just blew it off and did nothing. You say you didn't blow it off, and it's my term, but you did nothing about it. You just ignored it. You didn't address it. And that's not gonna fly here. You understand that?
I do.
All right. Spell anything else for the record that I should address?
Nothing further, Your Honor. Thank you.
Mr. Mulkey.
Nothing further, Your Honor. Thank you.
All right.
All rise.
probation is. All right.
Your Honor. We're before you today in State versus Nicole White. She has 2 separate cases. File 24 CR 1264 and file 25 CR 141. It's anticipated by the state of Ohio that the defendant will withdraw her previously entered plea of guilty, or not guilty, and enter a plea of guilty to file 1264. And furthermore, to waive her right to have her case presented to the Lake County Grand Jury and to enter a plea of guilty to a 1-count information in case 141. Other than what's been spread upon the record, no threats or promises are made to this defendant to induce these pleas. Thank you.
Mr. Langmaid, does that all sound accurate?
It does, Your Honor.
And Ms. White, were you able to hear what the prosecutor had to say regarding what he believes your intentions are here today?
Yes, sir.
It was indicated to the court that it is your desire in case 24 CR 1264 to withdraw your previous entered plea of not guilty and plead guilty to the charge in that indictment. It's also been represented to the court that it's your desire to waive your right to have the case in 25 CR 141 presented to the grand jury and to go ahead and plead guilty to a charge and an information, which I'll go over with you to make sure you understand these charges. Again, for sentencing, come back on a future date for sentencing hearing. You see something saying? It's also been represented there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is warranted. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right. Let's get started then. How old are you?
44.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, in case 25 CR 141, that's the case with the information. Did you receive a copy of that information? That's the
I looked at it, I guess.
So you did have a chance to look at it at some point?
Yes.
In that information, charged with one count of, there's two informations that were found in this case, right?
The one was withdrawn, Your Honor.
This is the one that, you have the wrong one up here, Stan.
This is the second.
Yeah, hang on. This is the first one that's up here. All right. In this information, what's alleged here is on or about February 9th, 2024 in Perry Township, Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or a compound mixture, preparation, or substance containing methamphetamine, a Schedule II controlled substance. The amount of the methamphetamine did not equal or exceed the bulk amount, which makes this offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
I understand.
Is there some other issue?
Well, I knew about it, I just wasn't, I don't know if you're trying to say that I was on drugs or something, but I was on probation at the time.
I'm trying to say that it's alleged in this information that on February 9th, 2024, you knowingly obtained, possessed, or used methamphetamine. That's what the charge is.
Okay.
That's what you're going to be admitting to.
Right.
That's what you're supposed to be admitting to.
Right.
Are you going to be?
Yes.
Are we wasting? So that you're going to be pleading guilty to that charge eventually.
Yes.
So my question so I wanted to read the charge to you, what the allegation is, and find out whether you understand what the allegation is, what the charge is.
Okay.
You understand it?
Yes.
Any questions for me about it?
No.
Now, in case 24 CR 1264, what is alleged in this count, in this particular case, is the same count, it's just a different conduct. Alleged that on or about October 12th, this is the indictment, 2024, in Leroy Township, Lake County, Ohio, that you didn't knowingly obtain, possess, or use methamphetamine or a compound mixture, preparation, or substance containing methamphetamine, a Schedule II controlled substance. The amount of methamphetamine was 2.02 grams, which does not equal or exceed the bulk amount, which makes this offense also aggravated possession of drugs and felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes.
Any questions about this charge?
No.
Well, then before I can accept your guilty plea to the two charges in each of these two cases, I need to make sure you understand all the rights you are giving up. And first of all, you have a right in 25 CR 141, that's the case with the information. You have the right to have this case considered and reviewed by a grand jury. A grand jury is made up of a group of citizens here from Lake County who get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And that's what you did in your other case. The case of the indictment was reviewed by a grand jury, and the grand jury returned that indictment. But you can waive that right if you desire and go forward on a charge brought by a prosecutor on what's called an information. That's the document that I read to initially. And your attorney has indicated he believes that that's what you want to do in this particular case, 25 CR 141. Is that correct?
Yes.
Well, before I can go any further in that regard, I need to have you acknowledge here in open court in writing that you do want to proceed by way of information. So I have a document called a waiver of indictment, which basically sets forth what I just explained to you about the grand jury process, and you want to give up that right. Again, I need to make sure you understand this document and that you sign it here in court. Now, my understanding is before I came out here, you had a chance to look at this document and review it with your lawyer. Is that correct?
Yes.
Mr. Langmack, is that accurate? Did you review this with Ms. White, read it over with her, and answer her questions?
That is accurate, Your Honor.
Did she indicate an understanding of the document to you when you did that?
She did.
Is that correct, Ms. White?
Yes,
Do you understand what that document said?
yes,
Do you have any questions for me about it?
no,
It also appears that you signed the document. Did you in fact sign it?
yes,
Mr. Langmaker, you witnessed that?
I did, Your Honor.
Mr. Geiger, you as well?
Yes, Your Honor.
All right, I will make that document part of the record. At this point, Ms. White, I'm going to go over with you all the other rights you have that you give up by pleading guilty. And these rights I'm about to go over with you apply to both cases. What I just did now is just the one case, but what I'm going to go over with you going forward applies to both cases. I'm only going to go over them one time, but I want to make sure you understand they apply to both cases. If there's something that applies to one case and not the other, I'll make sure I point that out, but otherwise everything applies to both cases, all right?
okay,
When first of all, then, you first have the right to have a trial in each of these cases, and that trial could be to me as a judge, where I listen to the evidence, and I would make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh out that evidence, and those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be unanimous, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
yes,
You understand by pleading guilty, you're giving up your right to have a trial in either of these cases?
yes,
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. Excuse me, you are presumed innocent of the charges in each of these cases, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
yes,
Now, when I talk about the burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
yes,
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
yes, sir,
Now, in order to try to do that, if we were going to have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. He could ask them anything he wanted to, within certain rules. Do you understand that?
yes,
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
yes, sir,
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted to. Understand that?
repeat that,
You have the right to call your own witnesses to come and testify for you if you wanted to. Now, you're not required to do that, but you have a right to do that if you wanted to. Understand that?
yeah,
And you further can request this court issue an order that we call subpoena, which would force or make someone come to court to testify for you and answer your lawyer's questions if that person didn't want to come in voluntarily on their own. You understand that?
yes,
Do you realize you're giving up that right?
yes,
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
yes,
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor there, he's not allowed to call you as a witness and make you get up on the stand and force you to answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
yes,
We further understand that if we went to trial and you were found guilty of any of these charges in either case, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted. as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're given up by pleading guilty. Any questions?
No.
You understand them all?
Yes.
Do you still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do this or it's someone else's fault or anything like that. Do you understand
Yes,
that?
sir.
Sorry?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you will, first of all, be found guilty by the court, and then secondly, on a future day, you'll be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you are pleading guilty in each of these cases to one felony to the 5th degree. A felony to the 5th degree is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, sir.
Now, since there's two separate cases here that occurred in separate incidents, if I did impose a prison term at any point, I would impose a prison term on each count, and as the judge, I would have the discretion at that point to run those prison terms either concurrent or consecutive to each other. Concurrent means you serve them together at the same time, whereas consecutive it means one after the other. You serve the first case, whatever it is, complete it, then you serve the prison term in the next case. So do you understand the difference there?
Yes.
So with both cases together, there's a maximum possible prison term of 24 months or 2 years in prison that you face. Do you understand that?
Yes.
Are you currently on probation or parole or any type of supervision in any other court right now?
I'm just not on a bond.
On
and
my
I got-
case?
And the, yeah,
On these cases that you're here for right now?
yeah,
Not any other case? So you have no other cases with another judge or another court pending right now?
no,
And you're not on probation in any court or anything? For any
not
past?
as yet.
No. We're talking about any past cases that you may have been sentenced to probation, anything like that?
I'm not on probation right now.
Okay, thank you. If a prison term were imposed in this case upon your release from prison, you could be placed on what is called post-release control. We sometimes call that parole. It's a period of supervision you would be on after you served and completed the prison sentence. In both of these particular cases, it could be up to 2 years of post-release control. Do you understand that?
Yes.
And if you were on post-release control and you ever violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence, there are other penalties that could be imposed. You could be fined. Each case carries with it a possible fine of up to $2,500. So with both cases together, that's a maximum possible fine of $5,000. You could also be ordered to pay court costs. You could also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment, if any that were applicable with any of these cases. Do you understand that?
Yes.
There's also a possible driver's license suspension in each case of up to 5 years. It's not mandatory, but the court has the discretion to do that. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory or required with either of these cases. Each case you pleaded guilty to, you would be eligible for probation, what's called community control sanctions. Do you understand that?
Yes.
Do you understand just because you're eligible doesn't mean it's automatic that you would get probation? It means it would be considered if that's what you're asking for. I'll look at all the information presented, then I would make the decision I thought was the right thing to do. Do you understand that?
Yes.
Now, if you were put on probation, it could be for 5 years of supervision. And as a judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes.
So just because if you were to get probation doesn't automatically mean there's no incarceration. It could, but it also could mean that you get local jail time as a condition of your probation. You understand that?
Yes.
Further, if you are ever put on probation and you violate any of the conditions of your probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions against you, or I could terminate or end your probation at that point and send you to prison then. And if I did it at that point, again, it could be 6 to 12 months on each count. Each of those cases could be consecutive to each other, so possibly 2 years in prison. You understand that?
Yes.
Lastly, when we do come back here for the sentencing hearing, you're going to have the right at that time to say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about these penalties that you face by pleading guilty, the potential consequences I just explained to you?
When will I know what the result is?
We're going to schedule sentencing in about 2 weeks from today. We'll come back and there'll be a sentencing hearing in 2 weeks, and at that time is when I will impose the sentence.
Okay.
Any other questions about what could possibly happen?
No.
Do you understand all the possible consequences that I just explained?
I'm fine with what you're saying.
Okay. You still want to plead guilty at this time?
Yes.
Have you had enough time to talk about the cases with Mr. Langmack and have him go over everything with you and answer your questions?
He's already done that.
You've had enough time to do that?
Yes.
And you don't need more time to do that?
No.
You satisfied with his advice and counsel?
Yes.
Has he or anyone made any promises to you about what's going to actually happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, then you have any questions for me at this point regarding anything we've just talked about? Any of the rights that you're giving up by pleading guilty, any of the possible penalties you face, what you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to speak with your lawyer before you go forward with your actual plea?
No.
All right, then what we're going to do at this time is the prosecutor here is going to explain for me what he believes the evidence would show in each of these cases. We'll do one case at a time. I need you to listen to him because then I got some questions for you about that, all right?
Alrighty.
So, Mr. Skagers, we'll start with 24th case, 24 CR 1264.
1264.
Please.
Thank you, Your Honor. The evidence would show that on October 12, 2024, the defendant was a front seat passenger in a vehicle along with her then boyfriend, now husband, Jesus Gonzalez, who was driving. They were subject to a traffic stop by the Lake County Sheriff's Department for a loud muffler and a stop sign violation. At the time, a canine was walked around the vehicle and alerted to the vehicle. The vehicle was searched. The defendant was holding a purse containing a black zipper bag with a crystal-like substance in it, a blue glass pipe, bubble pipe, and a small bag of marijuana. The suspected narcotics were sent to the Lake County Crime Lab where it tested positive for methamphetamine, 2.02 grams. And I mentioned the other items because they are all subject to forfeiture. Thank you. Should I proceed?
No, let's do this one first. Thank you. So, Ms. White, were you able to hear what the prosecutor had to say the evidence regarding what the evidence would show in this particular case if we had a trial?
Say that again?
Were you able to hear what he just said?
Yes.
He explained to me what he believes the evidence would be if we had a trial. What, if anything, do you have to say about that? Is what he said accurate? Did you do what he said?
The drugs stuff was correct, and the stop sign.
No, all I really care about is the drugs. That's what you're here for.
Right.
In terms of you knowingly possessed the methamphetamine. Is that accurate?
Yeah, it was in my purse.
You knew it was there?
Yeah, I put it there.
Very well, then regarding count 1, charging with aggravated possession of drugs with felony the 5th degree, this is in case 24 CR 1264. What is your plea at this time?
I'm guilty.
All right, Mr. Geigerich, we're going to do the other case now, so listen to what he has
All
to
right.
say in this case. This is 25 CR 141.
Thank you, Your Honor. 25 CR 141, the evidence would show that on February 9th, Lake County Narcotics executed a search warrant on the defendant's residence at 3536 Shepherd Road in Berry Township. That was after an investigation into sales made out of the house by her then boyfriend, new husband. Items that were recovered were Ruger 22 long caliber long rifle pistol, a Ruger EC9 pistol, and baggies containing suspected meth were recovered from bedroom 1. Digital scales with residue were recovered from the dresser in bedroom 1, which was the defendant's bedroom. 9mm ammunition was recovered. Dining room table, a prescription bottle with baggy powder, a silicone container containing suspected narcotics in the dining room. These items were sent to Lake County Crime Lab where they test positive for methamphetamine amount less than bulk. And I mentioned the scales, ammunition, and firearms due to the fact that they will be forfeited. Thank you.
There's no specification for that.
What's that, Your Honor?
There's no specification.
It's
for
voluntary. It's part of
that.
the.
Between you guys. Ms. White, we're able to hear what the prosecutor had to say regarding what he believes the evidence in this case would show if we had a trial.
Yes, sir.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said?
Well, I believe that was in the bedroom at the time.
Did you know?
I mean, they weren't mine, but they were. I know. I
Did you
knew
know
of
he
them.
possessed methamphetamine on that date?
I knew that there was there. Yeah. I don't know what the question is.
It's a yes.
Oh, yes.
You knew they were there.
Yes, I know it was there.
Very well, regarding count 1, charging with aggravated possession of drugs with felony the 5th degree. As for case 25 CR 141, what is your plea to that?
Guilty?
You asking me or telling me?
Guilty? I'm telling you.
All right, I have in my possession at this time 2 documents called a written plea of guilty and judgment entry. Each of them set forth everything I've just gone over with you.
Okay.
Before I can accept your plea, I need to make sure you understand these documents and that you sign them here in open court. Now, my understanding is before I came out here, you had a chance to go over these documents with your lawyer. Is that correct?
Yes.
Mr. Langmack, is that accurate? Did you review these with your client and answer all her questions?
That is accurate, Your Honor.
In doing so, did she indicate an understanding of them to you?
She did.
Is that correct, Ms. White?
Yes, sir.
You understand what these documents say?
Yes, sir.
Any questions for me about any of the contents in these documents?
No, sir.
It also appears that you signed the 2 documents. Did you in fact sign them?
Yes.
Mr. Langmack, you witnessed them?
I did.
That signature, and Mr. McTaggart, you as well?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with her attorney, advised of all her constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty in case 24 CR 1264 of count 1, aggravated possession of drugs, felony the 5th degree in violation of 292511 of the revised code. I will also accept the defendant's plea in case 25 CR 141 and find the defendant guilty of count 1, aggravated possession of drugs, a felony of the 5th degree in violation of 292511 of the revised code. Stan, do you have a trial sentencing date?
Yes, sir. Amy gave me 5/5 and 2 o'clock.
So sentencing is going to be deferred until May 5th. 2025 at 2 o'clock. Now, Ms. Wade, are you still going to see probation every week?
Me? Yes. Every Monday?
Every Monday by 4, I think it was? You've been doing that?
Yes, I've been going.
Okay, so as a condition of your bond, right?
Yes.
And you provide a urine sample? So you
Yes.
went yesterday?
Yes.
Right. All right, well, I'm going to continue your bond in 24 CR 1264. And I will set your bond in 25 CR 141 at owner cognizance. So the owner cognizance bond gets appeared at all future court dates. It's appeared for all cases, but if you don't appear at a future court date when you're released on an owner cognizance bond, that's a separate felony you can be prosecuted for, which is actually more serious than what you just pled guilty to. So it's obviously important you show up at all future court dates. And again, your next court date's May 5th. 2 stands, always said 2 o'clock.
Okay.
Understand that?
Thank you.
Why did you have on this form Ashtabula County for,
She has a,
That's where my house is.
there's a trailer there that they may need to move to.
We're just living at a friend's house right now because of the court.
so that's the Everett Avenue house?
Grand
That's where you're
River.
living right now?
Yeah, I'm living in Grand River right now,
But you have
but
a
we have
place
to
in
be
Ashtabula?
out of there soon, so
Okay.
our trailer's in
And that's in
Orwell.
Ashtabula County?
Yes.
All right. Anything else for the record?
Yes, Your Honor, I take it that we're using the PSR from the,
I mean, the PSR was done for both cases. I
Right.
guess I didn't realize that until I got out here.
so then we're just using that, correct?
Is there anything to update?
I don't-
that I know that I don't know about?
Not that I'm aware of.
I don't
I
believe
knew
so.
I was thinking that we only had that on one case and not the other initially, but when she filed initially, it was for both cases, so I think everything's been addressed in there. If there's anything
And
special.
she's seen them every Monday, so
Right, but I mean, there's nothing more to update in the PSR, right?
I don't believe so.
PSR cut was for both cases, so factually, the police reports are for both cases are in there.
That's correct.
So I'm just gonna have the entry say that PSR already completed.
You don't have to say that, you just say sentencing set for May 5th, I guess.
Okay.
I mean, if you want to put that in there, it doesn't matter.
I just don't know if you want that in there.
No.
And at this point, she doesn't have to go to probation right now. 'Cause
Not, if you're telling me you went yesterday,
Yes.
then you're good. And you dropped the urine screen yesterday?
Yes, sir.
All right, then you're all right.
Thank you, Judge.
All right.
All rise.
All right, we are here at 25 CR 085. It's case captain Isabella, State of Ohio versus Isabella Rotundo. We're here for a pre-trial. State of Ohio is present, represented by Assistant Prosecuting Attorney Barbara Zagretsky. And you are Isabella Rotundo?
Yes, Your Honor.
Say that right?
Yes, sir.
And she is here represented by her attorney, Mr. John Patika. So, Mr. Zagretsky, what's this all about? Just briefly.
Your Honor, most briefly, Menor Fire Department and Menor Police Department were called because the defendant was apparently overdosed in a tanning salon. She was revived at the scene, and in her room, officers confiscated contraband that they sent to Lake County Crime Lab, and thus we have the 2 charges.
The tanning room you're talking about?
Yes.
How was it discovered that she had overdosed? Or
She was not responding from the other side, so it was
she was
individual.
supposed to be done or getting out or something like that?
Yes, time was up. The tanning bed itself was off. Tanning bed's located in a room that locks. The owners of the salon did not have a key to unlock the door, and they couldn't get a response, so they called fire department and police department.
Thank you. Have you provided discovery? Tell them provided?
Yes, Your Honor, I did.
Defendant have any type of history?
I'm sorry?
What kind of history is there with the defendant?
There's a history of misdemeanors starting in 2022.
This is the first felony?
Yes, Your Honor.
Mr. Fatika, any thoughts you want to share or add here?
I just want the court to know that Ms. Rotundo has been proactive. She's engaged in an outpatient program. We have another case pending, preliminary hearing in Willoughby in the next week or so.
When did that happen? Allegedly happen?
I want to say like a week or 10 days ago.
While this is pending?
Yes.
Did you know about that in the case?
I did not.
So there's a new case being bound over?
It's separate.
Oh, it's separate. You don't know if it's going to get bound over.
I anticipate that it will. My rough plan was to see what happens with that and then see if the court will consider intervention.
Man, no problem if found. I had to wait for that, I agree, but I don't, if she's not on bond committing new crimes, that's a problem.
Yeah. And
I'm sorry, can I speak really quick?
I probably shouldn't comment on that other case.
Okay. That wasn't.
At least talk to your lawyer first.
Yeah. No, I understand where the court's coming from, but she has been proactive. She's being tested at as part of her outpatient. And
when did that start?
March 19th. She's at New Season in Menor.
So this other incident happened after she started that?
It did not. That's what I was trying to say, that this did not happen within the past few weeks. Could you get the date for that, please? The other case was about a month or 2 ago.
All right, don't comment on the specifics, but the other incident that's being, as a court case in Willoughby, when is that alleged to have occurred?
About 2 months ago.
When did this happen? This case?
This happened November 20th.
So she's still on bond, but she hadn't started treatment yet. Is that accurate?
Correct, Your Honor.
In regards to this case, Mr. Patika, any suppression issues that you're aware of?
not that I'm aware of, Your Honor.
What is the offer? Is it? I didn't ask you that, Mr. Grisky, I'm sorry.
And just to be clear, the incident happened on November 20th. The defendant was provided with the notice, the opportunity for her to get treatment so charges would not be filed. So charges were actually filed on January 6th. That's when a complaint was filed.
Community
And then
court.
shortly thereafter, she
Yeah.
would have been out on bond.
So it wasn't, between November and January, she was not out on bond at all.
Correct. And there's no offer.
Where's the, we said Willoughby, the other case?
Yes, Your Honor.
And when's the prelim set?
May 1st.
She's out on bond in that case right now too then?
Yes, Your Honor.
That's a bond, that's already been filed and the prelim set. All right, Mr. Kreska, anything else you want to discuss?
I would ask if it could be discussed that the defendant is on an OR bond so that she is notified.
I'm not going to do that. I'm sorry. I'm going to advise her that.
Okay.
Anything else you
That's-
want to discuss?
No, Your
Regarding
Honor,
the case
thank you.
itself? Yeah, I'm sorry. Yeah. Mr.
No,
Fatika?
thanks.
No, thank you.
All right, so Ms. Rotundo, you, all right. Your bond was set at an owner cognizance bond. It means you didn't post any money, you signed your name, that signature is your bond. When you are released on an owner cognizance bond, you have to appear at all future court dates. Well, you have to appear at all future court dates on any bond, but if you fail to appear at a future court date while released on an owner cognizance bond, that's a separate felony that you can be prosecuted for, which is actually more serious than what you're charged with here. It's a felony in the 4th degree that you can be sent to prison for up to 18 months on. So it's obviously important you show up at all future court dates. In this particular case, your next court date is the trial date, which at this point is June 10th. Now, there could be some other stuff that happens before June 10th gets here. Your lawyer indicated there's another case. If that comes over, that could cause a delay in that because that'll be sent. That case will automatically come to me. I guess my point is it's your responsibility to make sure you are aware of when your future court dates are. Your lawyer will attempt to notify you and send you notices, but if you don't get anything, that's not an excuse for not knowing. You can contact him, you can go online and look, but it's your responsibility to know when the court dates are. I'll tell you today, your next court date is June 10th. But again, if something should change, it could be different. If you are going to enter a plea of guilty to the charges in this case, your attorney would need to notify us of that 2 weeks before, no less than 2 weeks before the trial date, so approximately March 26th or so, not March, May 26th. If that were to happen, then we would schedule a change of plea before the trial date. So the change of plea hearing, if there ever was a change of plea hearing, would not be on the trial date, it would be before that. Your lawyer mentioned filing a motion for intervention of conviction. If that happens, that could postpone this trial date. You'd have to go to the probation department, get interviewed, and go through some assessments. You need to make sure you do that as well. So you just need to make sure you're hit off future court dates, all right?
Yes, Your Honor.
And you need to make sure you keep yourself aware of those dates. They're going to do what they can do. If you don't hear from them, you should not assume that the case is just, nothing's happening, all right? All right, anything else?
No, Your Honor, thank you.
Mr. Briskin, I'm sorry. Mr. Fatika?
No, thank you, Your Honor.
Thank you.